Good afternoon. I would like to call to order the Montana Public Service Commission. Would you please join me in reciting the pledge? Good afternoon. I would like to call to order the Montana Public Service Commission. Would you please join me in reciting the pledge? Good afternoon. I would like to call to order the Montana Public Service Commission. Would you please join me in reciting the pledge? Good afternoon. I would like to call to order the Montana Public Service Commission. Would you please join me in reciting the pledge? Good afternoon. I would like to call to order the Montana Public Service Commission. Would you please join me in reciting the pledge? Good afternoon. I would like to call to order the Montana Public Service Commission. Would you Thank you, Tracy. Roll call. Commissioner or Vice President Fielder, are you online?
I'm here. Thank you.
All right. Commissioner Molnar. Commissioner Pinocci.
Present.
Commissioner Bukasek. I'm Commissioner Wellborn. We have a quorum present with 5 commissioners. Moving to public comment. We have 1 public commenter in the room. It looks like we have Hertha Lund. Ms. Lund, please. Good afternoon and welcome.
I think I did it. Chairman Wellborn, members of the PSC committee, I've never appeared before this august body before, so thank you for welcoming me. I represent a group of landowners in eastern Montana. I'm an attorney from Lewistown, Montana. Well, originally, I'm from Martinsdale now. And I have a law firm where I represent landowners on property rights issues. And currently, I'm representing a group of landowners in eastern Montana where Highland Crude has sued in 2 different district court cases to take their property for a pipeline changing from crude oil to natural gas liquids. The issue that they've brought forward to you, I do not believe is part of your jurisdiction. Your jurisdiction is to regulate and to deal with those matters. Since this is in litigation and the issue they're asking you to decide is part of that case, my clients also were denied. So basically, Highland Crude filed a notice. They didn't necessarily ask you to do anything in that notice. It was just a notice. Now they want you to make a decision based on an incomplete record without the proper parties being present. And I don't think I'm prepared to argue substance, but right now I would like to prevail on process. And I would like the opportunity to supplement a record if you go forward on the substance of why it's wrong, what they're trying to do legally. And so the proper parties aren't here. My clients we did try to intervene and we were denied that. So this is an issue that should be played out in the district court. And I would ask you to not do anything on this at this current time. There's substantive problems that, again, I would like to articulate in writing if you choose to move forward. It's not properly filed. The process was hijacked by the industry without the landowners being present. So I would ask you to please table anything that has to do with Highland Crude and them asking you to determine that they're a common carrier. And again, that wasn't properly filed before you. They just provided notice that they were trying to step in the shoes of their old common carrier status. And this is something we're watching very closely because my clients' constitutional due process and Fifth Amendment private property rights are at stake. So thank you for allowing me to be heard on behalf of my clients.
Yep. Thank you. Thank you, Ms. Lund. We have an online commenter, Dave Jerica. Are you on, Dave?
Yes.
Welcome.
I can't see you, but can you hear me?
Yes.
Okay, I'll just read this comment I'd made. Thank you for the opportunity to comment. I just want to read a few statements.
Mr. Tarika, would you please introduce yourself and tell where you're from?
Oh,
Don't
gotcha.
use your address, please.
Yeah. I'm from Southeast Montana, from Powder River County. I'm a landowner here, rancher, my family. Um, I just want to read a few statements from the commission's documents. From the notice, there's a notice of commission action on intervention dated November 7th, 2025. Says the commission's authority following Highland's updated notice of acceptance is limited to accepting Highland's updated notice of acceptance. From the same document, it says, as a result of this limited authority, the commission has historically only issued a NOC in this type of docket. That is a notice of compliance. In the same notice of commission action intervention was denied and the findings were converted to public comments based on that limited authority. And then from the staff memorandum dated January 8th, 2026, Highland, this is what it says. Highland has notified the commission that it accepts common carrier status, and the staff believes the only action this commission can take is to accept the filing from Highland. So in 2013, Highland filed both a notice and an application and expressly asked the commission to act. That matter was noticed as an application and the commission voted. In this docket, Highland filed a notice only and stated it was not requesting commission action. Those statements are from the same commission documents and reflect how the scope of the docket has been framed from the start. So thank you, commission. Thank you for the opportunity to comment. I'm sorry. I hope you can't see me because I can't see you. So, all right. Thanks.
Thank you, Mr. Tarika. I believe that concludes our public comments. Are there any announcements? I would, if there's no others, I would like to take just a moment to acknowledging the passing of another one of Montana's energy heavyweights, gentleman that I served with back in the House of Representatives, Harry Clock, a representative from Harlowton, Montana. Harry served on the Energy Committee, I believe his entire tenure in the House. Anyway, my heart goes out to Sharon and Kyle and Danica and the family, and I believe his services there will be services later in the spring for Harry, but I just wanted to take a minute to recognize his service to the people of Montana. Thank you. Are there any further announcements? Seeing none, let's move to the minutes of the week of December 8th, 2025. Is there discussion on the minutes? Otherwise, I would entertain a motion to
It was terrible.
file.
Could they see me?
All right, would someone like to make a motion?
Mr. President, I'll move adoption or approval of the minutes for the week of December 8th, 2025.
Thank you. And is there
And-
discussion?
And Mr. President, while we're at it, I'll move adoption of or approval of the minutes for December 15th, 2025 as well.
Is there and it's been moved and seconded by Commissioner Bukasek, seconded it. Is there discussion? Seeing none, all in favor, please signify by saying aye.
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 Opposed? Motion passes unanimously. All right, moving along to agenda item number 1, docket 2025.09.063, the Northwest Energy PCAM to consider a notice of additional issue. Give staff a second. Good afternoon.
My apologies. I had the wrong item pulled up. Good afternoon, Commissioners. For the record, I am Teresa Omens, an attorney here at the Commission. With me, rate analysts Grant Fink, Neil Templeton, and Brooke Umstead. As you are aware, on August 29th, 2025, Northwestern filed its 2025 PCAM docket. On October 30th, 2025, the Commission issued a procedural order setting December 29th as the deadline for parties to request additional process. At the request of any party or by the Commission's own action, the Commission will determine whether additional process is necessary to resolve all outstanding issues for the docket. If the Commission believes an issue has not been adequately addressed by the parties in the proceeding, it can identify the issue and provide the parties with an opportunity to address it. The additional issue procedure provides parties with reasonable and express notice of the issues to be addressed and eliminates potential due process and fairness problems that arise from inadequate identification of issues in the docket. On December 15th, Northwestern requested that the Commission add an additional issue to this docket to address potential removal of the 90-10 sharing requirement and to request proposals for setting the PCAM base and deferral rates. Also, in Northwestern's most recent rate case, the Commission approved examining PCAM properties and the sharing mechanism in the current PCAM annual filing docket. The Commission also approved temporary suspension of the sharing requirements and ordered examination of the PCAM properties in the current annual filing or an investigative docket. Therefore, staff recommend further testimony regarding the 90-10 sharing is warranted to adequately address the issues in this docket and have suggested a schedule to do so. We're happy to answer any questions you may have.
Questions? Commissioner Molnar.
Thank you, Mr. Chairman. I assume for my legal colleague, as opposed to the others, but could be the others as well. There was a lot of discussion when we had the oral arguments as to whether or not it was even appropriate for this to be in a PCAM. When I read what we say goes into a PCAM, I can't find this. Why is this in a PCAM? Would it not be more appropriate in a separate rate case of its own, some sort of a separate hearing that seems to be a very separate issue from anything that has ever happened before?
Mr. President, Commissioner Molnar, what was addressed in oral argument is the motion for waiver of tariff provisions. What we're asking the parties to brief here is regarding the 90-10 sharing. So it's a different aspect of the overall PCAM. I don't know if regulatory can add anything to that, but it's a different aspect.
Yeah, Mr. Chairman, Commissioner Molnar, that this topic, the additional issue is something that was considered in the rate proceeding, the general rate review, and is part of the PCAM. So this is most definitely the place to review it, or a subsequent PCAM docket, or perhaps a docket of its own, but it fits pretty well as an additional issue into this proceeding. Thank you.
Follow up, Mr. Chairman.
Follow up.
Probably for Neil, seeing how this is actually two work items, 1 and 2. How did this become two separate work items on the same PCAM?
It's
Mr. Chair, Commissioner Molnar, there's two separate work sessions here, or items, because there's two different issues to discuss. And this first issue is the PCAM structure and the estimation of the base, and the overall estimation of deferrals and the timing of such, and importantly, the issue of sharing, the 90-10 sharing of the difference between base revenues and base costs. And so any discussion of the waiver that was applied for at the beginning of this docket, that will be the second work item, if that clarifies things. Thank you.
I've never understood the PCAM. Nothing can clarify on my behalf. Mr. Chairman, a quick question for Brooke. It's kind of item 1 and item 2 both have the same docket number. Brooke, you've seen my alternative motion. Do you think it belongs more on work session 1 or work session 2?
President Wellborn, Commissioner Molnar, your substitute motion would work well with the work session item number 2.
Okay, thank you.
Further questions?
Quick one. Is there a economic breakdown on what happens if we do the 90-10 set aside and just go to 100%?
Mr. Chairman, Commissioner Molnar, the 90-10 sharing is sharing the difference between the base revenues and base costs. Now, the base revenues are the revenues that are collected using the base rates, which are determined in the rate case. Now, the base costs are whatever costs are required to serve customers, so not including QFs and some other issues, but so those would be the base costs. Now, the difference between those currently shared 90% to customers and 10% to utility, whether it's an under and over collection. Now, the economic effect, if you mean by that the financial effect on that, how much would actually be transferred or changed, redistributed from shareholders to customers or vice versa, that would depend on how the commission rules. This is just going to be an additional issue in this docket. So there would be testimony and then a hearing and briefing, et cetera. And when the commission makes its final decision on whether to say, to remove sharing and what other adjustments it might make to the PCAM structure, that decision will be made at the end of this docket. And then the decision presumably would also make a decision regarding what time frame that as far as all the interim periods are, or, for instance, the interim periods that would be covered under that order. And currently, all the periods, in my understanding, from July of 2024 through June 25 are the ones that are at issue in this docket. And they're considered to be interim until the commission finalizes those numbers and for rate recovery or deferral in future rates. Now, so that the actual financial effect of any removal of sharing or change to the sharing mechanism depends on the commission final decision. It would not be made at this time. Thank you.
Thank you, Neil.
Mr. President, would you entertain a motion at this time?
I would.
Mr. President, I move to approve the draft notice of additional issue and authorize staff to make any non-substantive edits as necessary.
Is there a second?
I'll second.
It's been moved and seconded. Discussion on the motion.
Yes, Mr. President, this is, I think the question and the discussion that just occurred are important questions and discussions, and by approving this motion for additional issue, the commission will be able to dig into this and hear from different parties on this and analyze whether this sharing requirement, what the effects of this sharing requirement or waiving the sharing requirement are. And I really want to dig in deeper to this. I've always thought some type of sharing arrangement was an important arrangement to maintain. And I know in our last rate case, we put a waiver on that and said we would address it in a future rate case. And I think this is an opportunity for us to start addressing it sooner rather than later.
Thank you, Vice President Felder. Further discussion? Seeing none, I'll call for the question. All in favor of Vice President Felder's motion to approve the draft notice of additional issue and authorize staff to make any non-substantive edits as necessary. All in favor, please signify by saying aye.
Aye.
Aye. Aye. Opposed?
Aye.
The motion passes 4-1 with Commissioner Molnar dissenting. All right, moving on to agenda item number 2 is also the same docket, which is 2025.09.063. Looks like we have the same staff prepared to give us an update.
Good afternoon, President, Commissioners. We are here today to act on Northwestern's proposed motion included in its PCAM application in docket 2025.09.063. The motion requested to use net market sales revenues from 3 newly executed long-term power sales contracts, also known as designated contracts, to offset operation and maintenance cost, or new Colstrip O&M, related to the Avista Corporation's 222 megawatt share of generation capacity from Colstrip units 3 and 4 that Northwestern acquired on January 1st, 2026. Specifically, for the period January 1 through December 31, 2026, Northwestern proposes to exclude PCAM sales revenues accruing to the designated contracts, exclude PCAM fuel costs equaling the cost of Colstrip fuel required to satisfy the designated contracts, and credit, when those PCAM adjustments are addressed in a rate review, any excess designated revenues to customers if designated revenues less fuel adjustment exceed new Colstrip O&M. If net sales revenues from the designated contracts fail to cover the new Colstrip O&M, Northwestern will not seek to recover the shortfall from customers. Both Montana Consumer Council and Montana Environmental Information Center and Sierra Club filed a notice of intervention in this docket. On November 10th, 2025, MCC and MEIC filed a response to Northwestern's motion. Northwestern filed a reply to its motion on November 24th, 2025. The commission heard oral argument from the parties on December 9th, 2025. On December 22nd and December 31st, 2025, MEIC and MCC respectively filed testimony on the application, some of which addressed language on the motion. Notwithstanding the parties' data responses and oral arguments on the motion, staff observed the commission could benefit from additional process, which would include testimony, discovery, public hearing, and briefing before making its final decision on prudency of the motion. Approving the motion on an interim basis in the current docket would allow the motion to be fully vetted as the docket proceeds. Therefore, staff recommend the commission direct staff to draft an interim order approving the motion on an interim basis, with rates effective January 1st, 2026, pending a supplemental order to be issued at the completion of this PCAM docket. Approval of the motion in the interim does not preclude the commission from adopting a subsequent interim or final order. That is all I have for you today, and we're available for questions.
Questions from the commission? Commissioner Molnar?
Thank you, Mr. Chairman, Mr. Fink. Apparently, this is for 58 megawatts. What happens to the rest of the megawatts from the Avista share of CU4, the formerly Avista share of CU4?
Mr. President, Commissioner Molnar, it's my understanding based off the parties, Northwestern, that share is going to be used for customers.
Okay. Can they, okay, that was my understanding from your arguments as well. But is there any preclusion from them getting more contracts than just Energy Keepers and Bighorn?
Mr. Chairman, Commissioner Molnar, I believe this motion only and the waiver only considers the designated contracts, Energy Keepers and Bighorn County. And I believe, to clarify, I believe there's a maximum of 70 megawatts, and 58 would be more of an average or estimated. Thank you.
Thank you, Mr. Chairman. Neil, can you tell me where I can find that 70 megawatt figure in here? I don't remember reading it.
Mr. Chairman, Commissioner Molnar, that may be my own calculation based off other information that's not included in the memo, but that was my understanding.
Yeah. So it's not written in here?
It's not in the memorandum.
Okay,
I don't believe.
Thank you. There's some collaboration going on, Mr. Chairman. Has there been a finding of 70 megawatts somewhere? Okay, Mr. Chairman, I would like to try a substitute motion, if I might. What do we?
A motion.
We don't have a motion.
Yeah, we don't have a motion, so,
I'll go into recess.
okay. Are there any other questions from commissioners?
Yes, I have one, Mr. President.
Yeah, go ahead, Vice President, and then Commissioner Bukasek has one as well, so.
Okay, I just want to be clear. So Northwestern's motion was to have this this use of net market sales revenues from these executed long-term power sales contracts just for this year, for 1 year only. Correct, staff?
Mr. President, Vice President, yes, that's correct.
Okay. And the staff recommendation here, and I really appreciate the way that staff laid this out. It is a complex issue. And I think that the recommendation here from staff to approve the motion on an interim basis, I think that's a good proposal from staff. But I wanted to just be certain what it is staff sees as an interim basis. Do you see the interim basis that you're recommending aligning with this 1 year period that aligns with Northwestern's motion of January 1st, 2026 through December 31st, 2026?
Mr. President, Vice President, staff's recommending an interim relief be granted until a final order is issued in the PCAM, where we can then make a final decision on this motion. That may be less than the year. I will note that we are drafting a tentative procedural order at this point, which would set a hearing roughly in August. So there is a chance that it could be less than that year before we make that final decision. I guess there is the chance that it is longer than that year.
Okay. And from what I understand here, Northwestern has entered into these contracts. They're not retail contracts, they're wholesale contracts to sell a certain, I think 50 megawatts to the Energy Keepers, and then 8 megawatts to, I think it was Bighorn Co-op. And is there a third party that I'm missing that they are planning to sell to?
President Wellborn, Vice President Fielder. There's 2 contracts with Energy Keepers and 1 with Bighorn. So that would be the 3. You're not missing another party.
Okay, thank you for that clarification. That is helpful. So, as I understand it, then the sales revenues from those contracts, which are wholesale contracts regulated by FERC, those revenues would be used to cover the operations and maintenance costs at the new coal strip, and also the fuel costs at the new coal strip. Is this for the Avista share that they've acquired in units 3 and 4? So those revenues would be from these contracts would be put towards the new Avista shares that Northwestern acquired from from Avista for units 3 and 4.
President Wellborn, Commissioner Fielder, that's correct.
Okay. And so this is a way for the maintenance and operations of the new coal strip acquisition to be covered by those wholesale sales rather than by Montana retail customers. Is that correct?
President Wellborn, Commissioner Fielder, that's correct. Those revenues will help offset the O&M cost in this motion that Northwestern seeks, and the
Okay.
fuel cost of the coal strip new Avista share 3 and 4.
Okay. And if those sales revenues don't cover the coal strip operations and maintenance costs, Northwestern has agreed here in this motion that they won't seek to recover that shortfall from customers in the future, correct?
Commissioner Fielder, that's correct.
Okay.
And
So it seems
Commissioner
to me,
Fielder, just before we move on, I think Brooke had something to add to your last question a little bit.
Okay.
I'll let her pop in here.
Thank you.
Thank you.
President Wellborn, Vice President Fielder. I was just going to add, when you mentioned the wholesale versus retail customers, that typically in the PCAM, Northwestern, for example, in the last PCAM period, had over $60 million in revenues from wholesale sales in the last PCAM tracking period. And typically those sales always flow through to as credits in the PCAM. So it's not just these designated contracts aren't necessarily different than what's been done in the past.
Okay. Thank you for that.
All right. Did you
All
have
right.
additional questions, Vice President Fielder?
No, I think that answers my questions for now. Thank you, Mr. President.
Yes. Commissioner Bukiczek.
Thank you, Mr. President. So I've had my questions adequately answered by staff, but for the sake of the other commissioners and for the public, I'd like to ask them again. So appreciate your tolerance. So from the last paragraph of page 7 of staff's memorandum, it's about what would happen if Colstrip failed and was unable to serve the contracts without going to more expensive resources. The last line says the risk of retail customers subsidizing Northwestern contract obligations should be carefully examined should Colstrip fail. So that's what I'm referring to in my question. It seems to me we don't have any way to estimate the risk with any certainty whether Colstrip's going to fail or not. Would you agree?
Mr. Chairman, Commissioner Bukiczek, not necessarily. I would agree that the commission does not have before it any models that could be used or considered to estimate that risk. There are some factors that should be considered, potentially, as was said, that the contract load is, say, 58 megawatts. The new coal strip in this proceeding is 111 at 3 and 111 at 4. So it's kind of the image of Northwestern's current 222 megawatt share, 30% of Unit 4, which has a sharing agreement with Talon where 111 is distributed to 3 or gotten from 3 and 111 from 4. So there's some reduction of risk in that alone. That should be considered. The entirety of Colstrip would have to go out, both 3 and 4, if presumably, or some other additional features for them not to be able to serve the contracts at all. But so there is some risk mitigation in that is kind of similar to the risk that they currently bear at their Unit 4 share. But as far as, well-developed models, that no one has brought forth anything like that to the commission. I'm not saying it can't be done. It just has not been done. That's all. Thanks.
Okay. So that redundancy provides a certain level of risk mitigation, as you said. So if the waiver request is granted and New Colstrip was, let's say, unable to provide what's needed in their contracts, would the commission have some latitude for some kind of emergency intervention?
Mr. President, Commissioner Wellborn, the commission could bring this matter before them, I believe, by a commissioner, if a commissioner proposes that at a work session, or else could wait until staff brings the final recommendation pending a final order back before them.
But the situation would only be applicable if New Colstrip is not operating. So something could be called at that point, not prior to that. Wouldn't make any sense. We would be responding to an emergency, so nothing would happen prior.
Commissioner, sorry. No, go ahead. Sure. Quite follow.
Mr. Chairman, Commissioner Bukacek, the actual the mechanics, how this will work out in real practice depends a lot upon market prices and the dispatch of Northwestern's resources. Staff is currently assuming that as in avoided cost calculations, that the production at New Colstrip will offset a piece of the stack at the highest portion. So if the marginal price to serve load is higher than the actual fuel cost of Colstrip, then it will offset an amount of production at the top of the stack just to serve load. So in that case, the savings from that avoidance will cover and will probably actually provide some benefit to customers, and it alleviates the risk of the utility not being able to cover the price of the contracts in the absence of the waiver. In the presence of the waiver, then they remove the price of the revenues from the contracts as well. So, and if the price is below the cost of Colstrip, then under the waivers, they would be deducting the cost of Colstrip, which would more than cover the cost of whatever it would cost to serve load, including the designated contracts. So it appears as if unless the new share is not producing enough electricity to actually serve the contracts, the 58 megawatts or whatever it might be, to serve those contracts, if it's not able, even though it would be dispatched economically otherwise, in other words, there's an outage or a shortfall of some reason, then unless it's not producing that electricity to serve those contracts, then I would say, at least at first glance, that customers are not going to be exposed to severe risk of subsidizing anything.
Thank you.
Further questions?
Yes, Mr. President.
Go ahead, Vice President.
Thank you. I want to make sure that we're clear procedurally on something Commissioner Bukacek asked. And the recommendation as it's written here, and what I presume will be a motion that's made, is to draft an interim order approving the motion on an interim basis. That's Northwestern's motion on an interim basis, pending a supplemental order to be issued at the completion of this PCAM docket. And so the way I read that, and I want to be clear with staff, is that if the commission adopts that position, recommendation from staff today, that the motion would be accepted on an interim basis, but then that would be supplanted by a final order to be issued after the commission has hearings and makes decisions and reaches a conclusion on a final order at the completion of this PCAM docket, which is expected later this year. Is that right?
Mr. President, Vice President Fielder, yes, that's correct. We're treating it very much like we would interim rates, where we are granting them in the meantime, and we'll come out with a final order at the end of the PCAM docket.
Okay. Thank you very much.
Further questions?
Sure.
Commissioner Molnar?
Thank you. I'll throw this at Brooke. With the statement in there that if there's a shortfall of revenue from the sale of the 57 megawatts, that customers would not be held, regular customers would not be held responsible. Is there still a possibility of cross-subsidization the way this is written?
President Wellborn, Commissioner Molnar, I think there, as staff mentioned in the memo, there's a risk of the cross-subsidization, whether the motion is approved or not, with how the designated contracts are written, and that issue is ongoing and can be fully vetted through this process. The first part of your question that you mentioned, where the revenues, if the designated contract revenues cannot fully cover the fixed O&M, then shareholders would borne that fixed O&M costs, which that safeguard is in place, which is great, but it does not reduce the risk of cross-subsidization.
Further question, Mr. Chairman. I've been at this so long, I should be able to say I know the answer to this, but I don't. Okay, so let's assume we passed the memorandum. How legally binding is that when we haven't made a final order yet? It's got to be open to interpretation, and the courts might get drug in, or is this pretty solid that customers will not be drug in, except as you say they might be? And I think anything can happen, so I'll go along with might be. Maybe this would be a question more for you. How strong is our legal position based on reliance to a memorandum before we have a final order?
Mr. President, Commissioner Molnar, my initial thought is we are treading into legal advice, and I would hate to waive that attorney-client confidentiality based on that advice as far as legally binding goes. But again, I will note, as I did with Vice President Fielder, that we do issue interim orders all the time for interim rates for almost, over half of our cases, I think. So it is something that we do frequently, and as far as I'm aware, our ability to do so has not been questioned in the courts.
Thank you.
And Mr. President, if I may have a third turn here, I'll take it.
Yep, by all means. Go ahead.
Okay, thank you. So going to Commissioner Molnar's question, I too have a little bit of concern about that. The recommendation from staff, would authorize staff to draft an interim order approving the motion on an interim basis. pending that supplemental order to be issued at the completion of this docket. And there's a note there also that approval of the motion in the interim does not preclude the commission from adopting a subsequent interim or final order that changes or reverses any adjustment approved. So what I am planning to do, if you'll permit me, is I want to make a motion that includes that language too. So it's clear that the commission can come back and revisit this at any time the commission decides it's necessary to do so, until a final order is issued on it. So I guess I'll throw that out there and ask staff, legal staff, if they have any concerns about framing the motion like that.
Mr. President, Vice President Fielder, I just would like to clarify, you're just requesting that we include that language in our interim order. Is that correct?
No, what I'm thinking here is to take your first paragraph of the recommendation, staff recommendation, and append it with the note that follows in the next sentence. So I would roll those two into one motion, so it's clear that it's this draft interim, or this interim order, wouldn't be only pending completion of this PCAM docket, but would be subject to the commission coming back and revisiting this in the meanwhile, if the commission finds it necessary.
Thank you for the clarification. There's no legal concern for adding that.
Okay, and I think that would resolve some of the discussion we've heard from Commissioner Molnar and possibly even Commissioner Bukacek, and it would ease my mind a bit too, to be able to have some flexibility, because this is different. I think that we're thinking out of the box here. I think the utility's thinking out of the box here a little bit, and staff's recommendation facilitates that. And I think that it's worth trying, but I want to have the flexibility to come back and change course if we find it's necessary during this year. So I guess that's my final comment, Mr. President, Mr. President and members.
Mr. President.
Commissioner Bukacek.
Recommendations to address Vice President Field, the recommendations already include that. So all that would need to be changed is how the motion is made, correct? There's nothing else that needs to be changed because it's already officially in your recommendations.
Mr. President, Commissioner, yes. I believe that's what Vice President Fielder was suggesting, was that it simply be added to the motion verbiage.
Yes, Mr. President and Commissioner Bukacek, my intent here is to introduce a motion that would clarify that. And no, it's not changing the recommendation. It's just putting it together so that we're covered for flexibility.
Sounds great.
Go ahead.
Just one more clarifying, and it's already, again, clear to me, but staff has already stated it could be more or less than a year than the year requested by Northwestern. Less than a year if things go quickly. We have the hearing in August, and before December 31st, everything's settled and we're all done. But there's also, given the history of Montana regulatory lag, it could also go past that. So I just wanted to clarify it could go either way. Is that correct?
Mr. President, Commissioner Bukacek, yes.
Thank you.
All right, thank you. Further questions?
There hasn't been a motion yet, has there?
No, there hasn't. Commissioner Vice President Fielder, would you like to put that in the form of a motion if there's no further questions from our commission?
I'd be glad to. Yeah, I wanted to make sure commissioners had an opportunity to ask their questions of staff before we went into a motion and debate as a commission. So if we're at that point, I'd be glad to introduce the motion.
Go ahead.
All right, Mr. President, I move that the commission direct staff to draft an interim order approving Northwestern's motion on an interim basis with rates effective January 1st, 2026, pending a supplemental order to be issued at the completion of this PCAM docket, or a subsequent interim or final order that changes or reverses any adjustment approved as the commission may find appropriate.
Discussion.
And I'll second.
Thank you. Discussion.
Mr. Chairman, I'd like to try a substitute motion if I might. Mr. Chairman, fellow commissioners, those here gathered, my motion on 2025.09.063, staff is directed to develop and present to the commission a plan to economically dispatch generation from Vista Colstrip 4 to Montana captive customers and allow Northwestern Energy to market-base the sales of electricity from Northwestern's Energy CU4 holdings, with half of the profit realized to go to Northwestern Energy and the other half to go into a special revenue account on behalf of Northwestern Energy customers to be applied to O&M and property taxes of Northwestern Energy Legacy CU4 holdings, as well as the Avista acquisition. Last sentence, contract monetary shortfalls from Northwestern's market contract sales are not to be borne by Northwestern Energy customers. Thank you, Mr. Chairman.
Is there a second?
I'll second.
Okay, substitute motion has been moved and seconded. Discussion.
I'd like to defend my motion, sir. The difference between what's been proposed and what I'm proposing is bedrock future findings as well as this. Under mine, the Montana consumer receives the low-cost energy. And contracts, be they to energy keepers, Bighorn, data centers, as is proposed for some, they get the market base. We get the lower cost. However, Northwestern is very correct. They should not have rate-based assets at no cost, and therefore no way to handle O&M and taxes. I don't know, and that's why I want the staff to present and develop, instead of us getting what's left over from the sale, which may or may not be much. They get half, we get half. They have an incentive to get good contracts. We have an incentive to let them do it. I think it's very, very fair. I am not asking for a final vote. I'm asking for an investigation by staff, discussions with Northwestern. How can we make this work? But at no point can I go along with residential customers pay $70 a megawatt for CU4 and Bighorn customers pay 45 or 50. At no point, sir. Can I say that if our winter drought becomes a summer drought and our hydro and the hydro BPA is not producing anywhere near capacity, and when BPA goes to market, they don't have a financial claim, a financial top. They just have targets. There may or may not be, in a region-wide drought, energy for us to buy. If we do, and we may be back into $1,000 a megawatt, but not for 4 or 5 days, for 4 or 5 months. If during that same time, this energy is used to provide contract energy at 50, people would have a right to storm the gates. That is why I'm bringing this forward, to make sure that the position of the captive ratepayer and the position of Northwestern and their investors are held at a 50-50 par, Mr. Chairman.
Thank you for that explanation.
Mr. President.
Yeah, Commissioner Bukacek.
In a defense of his motion, Commissioner Molnar talked about his desire to not undermine Montana residential customers, but his motion can also undermine the residential customers. It's looking at the short haul, but we regulators are very capable of considering the long haul cost to customers. There's a very real adverse effect on investor confidence based on the historic unpredictability, uncertainty, and sometimes strangeness of the Montana regulatory environment and decisions. This lack of confidence raises the cost of capital for the utility and ultimately raises Montana's electricity bills. This motion of Commissioner Molnar's, with all due respect, is not looking at the long haul aspect. Thank you.
Thank you, Commissioner Bukasek. Discussion.
Mr. President.
Yeah, go ahead, Vice President Fielder.
I don't mind looking at the ideas presented here from Commissioner Molnar, but to have them presented at this point where there's been no evidence gathering, no weighing in by parties, no opportunity for parties to address the content of his motion, I think is gets backwards with due process. So I think it's something that we could probably look into and explore and flesh out in the proper way while this interim order is in effect. But I don't think it would be legal. I don't really think it would be legal to throw to throw something brand new into this that isn't part of the record or the proceeding at this point. So I guess I'm saying I'm open to discussing and ideas, but I think the motion at this time is misplaced, procedurally misplaced, and would violate due process for the parties that are involved in the docket.
Mr. Chairman, can I respond?
Yeah.
Thank you, Mr. Chairman. In response, nothing in my substitute motion takes out the first motion. It's an addition. While they are looking at how to do what is proposed, they can take a look at economic dispatch with Montana ratepayers getting first bite at the cheaper electricity instead of what's left over. These are this is set up for, as I mentioned, a discussion between Northwestern and our staff. I can't get into it because I'd have to vote on it, so I'm out. But to find out if a 50-50 split is something Northwestern perhaps hasn't thought of, but might think with their own calculations is worth a stab. I would point out that everything we've heard about so far, which includes the possibility of cross-subsidization, has been argued or discussed based on if it goes really bad, we can meet again. If we try to reverse something, we are into reverse rate making. We are coming in after the fact. The best we can do is after the fact. And I have no idea what that catastrophe could be. We certainly had one January of 24. I think we're looking at one if the drought continues. I think that if Colstrip 4 under whoever used to own it goes down and Northwestern has to go to market, and if that market is not there, and if we can't get market to backfill, it's a brave new world. So I'm saying throw this into the mix of things to discuss and bring it back to us. I'm not knocking out the first one. I'm adding it.
Okay, Mr. President, with that explanation, and Commissioner Molnar, I think that the substitute motion is not a motion that you should make because a substitute supplants the other motion that's on the table or that's been made. So what you should do if you want to achieve what you just described is we need to deal with the first motion, and then you would introduce just a separate motion to direct the investigation of the topics you want to explore. And that could just be a separate motion.
Mr. Chairman, I'm
But a
not
substitute
exactly
motion.
sure that I agree with that because I'm not knocking out the first one. She may be correct. Is there somebody that can rule on that as opposed to simply have that statement?
Well, the president has the ability to call on a parliamentarian if he wishes. That's entirely up to the chair of the meeting. But I think
we can do it one of two ways. You can either withdraw your substitute motion and then bring it back on its own strength, or we can take a vote of your substitute motion and dispense of it accordingly, and then
I can bring the other one back.
Ye-
They can bring it back as an additional item. I mean, it's probably not all that important to whether or not the sun comes up tomorrow, but all I'm saying is staff is directed to develop. I think the title of the motion is probably immaterial because I'm not saying in lieu of. What do you think, Mr. Chairman? I think our parliamentarians are in a huddle over there.
Substitute motion takes the place of the other motion. It's just basic parliamentary procedure.
Well, Mr. Chairman, I would have a tremendous amount of difficulty voting on the first one and hoping the second one passes.
There is the substitute motions on the table. It has been moved and seconded. If somebody would want to call for the question, we can take a vote on the substitute motion.
I call the question.
Question's been called for the substitute motion. I will read it back in for the record. The staff is directed to develop and present to the commission a plan to economically dispatch the generation from Avista Colstrip 4 to Montana captive consumers and allow Northwestern Energy the market-based, the sales of electricity from Northwestern's Colstrip 4 holdings with half the profit to realize to go to Northwestern Energy and the other half to go into a special revenue account on behalf of Northwestern's captive, customers to be applied to the O&M and property taxes that Northwestern Legacy Colstrip Unit 4 holdings as well as the Avista acquisition. Contract monetary shortfalls from Northwestern's market contract sales are not to be borne by the captive customers of Northwestern Energy. All in favor of the substitute motion, please signify by saying aye.
Aye.
Opposed?
No.
No.
No. Substitute motion fails 2-3 or 3-2.
2-3.
Onto the motion, back on the original motion from Commissioner Fielder. Is that, we haven't called for the question on that, have we? Is there further discussion? Yes.
Thank you, sir. So I wanted to give my defense of Vice President Fielder's motion, if I may. Okay, so based on Montanans' desire and need for reliability of electricity, granting the waiver is an easy yes vote for me. Assurance of that reliability is enhanced by additional resources, of course, especially generation resources located within Montana that supply baseload power. My most outspoken constituents are strongly behind optimizing Colstrip for the sake of resource adequacy protection. In their view, and I agree, supporting the viability of new Colstrip is justified based on the likelihood of it supporting reliability and resource adequacy and mitigating against price volatility. The uniqueness of the utility's request correlates with the unusual and desirable circumstances of having zero capital cost, a valuable resource asset, excess capacity, and the opportunity to sell excess power into the market. The utility is taking on the risk of the O&M costs, the risk of repaying customers with interest, while investing zero capital costs means no upfront profit or return for the utility. Although new Colstrip began serving customers January 1st, the new Colstrip O&M cost will not be included in customer rates until the future rate review, as was discussed. That leaves an estimated, I believe it's $18 million gap. At the end of the day, this is an interim request, a request to partially fill that expense gap for an asset considered needed. Colstrip is highly valued by my most outspoken constituents. Good cause exists to grant the temporary waiver, because without it, the customers would get the benefits without shouldering any of the cost. That cannot be considered fair. Those are benefits of enhanced reliability, possible excess market sales credit in the PCAM. Requesting to recover O&M costs for new coal strip in the interim is fair and just. Because it is an interim request, prudency review is not required to grant the motion. Staff's recommendation is granting the interim until a final order of the PCAM docket is issued. So it's all fair and just. That's my defense.
Further discussion, Commissioner Pinochi.
I have a question for staff. So we have two motions. A concern that I'm not seeing brought up here is my district, and I think most of Montana, the energy needs are growing. Governor just announced an 80,000 square foot facility in Bozeman. It's going to require a lot of power. My district is telling me that construction of new companies coming in are the concern that we don't have adequate power. So which motion is going to ensure my ratepayer gets that additional power if they need it? Now, I think it's great that Northwest Energy is trying to make a contract to go to another customer, but the constituents I represent are going to get very concerned if the power going there is going to be half the price of the power they're going to need. And keep in mind, Montana is growing at a record rate, which has broke the record for the most amount of energy ever used, right? And that's going to continue to go up. Which motion supports my constituents getting a better price? Can you answer that for me? Which one would you choose?
Mr. President, Commissioner Pinochi, for the record, I would say that we have one motion on the table, considering one was just voted on. However, I would say that neither motion ensures that they get a certain rate. Both of these, one is an interim decision and one is, from what I understood, an investigation. And so neither one is a final decision that would set rates for consumers.
Mr. Chairman, Commissioner Pinochi, to add on to that, I think part of the kind of the unheard story yet in the first motion is that customers approved coal strip unit 4 for pre-approval or the commission did for the customers in 2008, beginning Jan 1, 2009, and at $400 million capital cost. And that's currently and has been serving Northwestern's customers for many years now. And now Northwestern, this Avista shares equivalent capacity. It's spread over 3 and 4, but it was acquired apparently at zero purchase price with cap fixed O&M coming along with it. So I guess the idea is that if the new share was to serve customers at essentially zero cost except for the fixed O&M, that it would be much less expensive, maybe a third or even a quarter of the cost of the original, on a per megawatt hour basis after adding in the fuel costs and whatever. And so it would be cheaper to distribute that to customers. Now, the customers can't get away from the pre-approved $400 million purchase in 2008. Now, if Northwestern brings this Avista share into rate base, then customers will be served by the Avista share, or new coal strip as it's called in this. And they will be liable for the fixed O&M, and they will be liable for any CapEx going forward. And they will receive the full benefit of any market sales on top of serving load that the new share is actually responsible for. So I'm not really sure if either emotion addresses the underlying condition here as I'm trying to understand this question. Is it the only way to really average the benefit to customers of the legacy resource at Coal Strip Unit 4, which was purchased at a fairly high price and is probably, maybe still in the neighborhood of 70 megawatts per hour, and this new resource, which would be more in the neighborhood of, say, $40 an hour all in, is to bring it into rate base, but that has not been proposed by Northwestern. It's not before the commission today for a full prudency evaluation of the resource and its interest into Northwestern's rate base and its portfolio. So I'm not trying to, kind of insert comment here, except I think there's an underlying question that needs to be addressed, and I'm not sure that either of those motions really addresses it. Thank you.
Well, let me ask you, do you think you have an idea for a motion that would address these concerns?
Mr. Chairman, Commissioner Panocci, the commission could potentially force, I don't think it's warranted in this proceeding, Northwestern to bring this resource into review. I mean, kind of fish or cut bait, whatever. But I don't think this is the proceeding for it. I think Northwestern has indicated that they would like a full year of results as kind of a shadow kind of interim member of the team of their portfolio to see how the resource operates within the context of their organization before they bring it in for review. And typically the commission allows the utility to make its decision when to bring it in for review. But if, in response to what I was just saying, if you want to have it brought into the portfolio, then there needs to be a proceeding where it's used in usefulness and a careful examination of risks and benefits that might be accruing to that resource in the portfolio where they can be fully vetted by all parties. Thank you.
Mr. President,
Commissioner Bukacek.
I appreciate staff's involvement and staff's answers, but we're past the point of asking staff questions. It's supposed to be discussion amongst us. Get on to a vote.
Further discussion?
Sure. Not to beat a dead horse, but Neil's right. And then we'll get to the dead horse part. What this says, the motion before us, is that new customers of Northwestern will get the energy provided without capital expenditures being added on. Those have been paying since 2009 on CU4 get to continue paying a $70 price tag on a $45 product. That's not right. The consumer should, at some point, receive priority from this commission because we're supposed to be bringing balance between the customer and the utility, and it certainly does not. That's statutory. Further, I used the wrong word prior to this, so I'll correct it now. If things go real wrong, we are relying on retroactive rate making to fix it, and that's not going to fly. The best we can do is for the future, assuming that the catastrophe continues to unfold. Which means, while we're in court discussing it, it may be moot because the issue is over. It snowed. It rained. A 4.5 on the Richter. They got cold strip 4 working again. Whatever it might be. We are saying we will rely on our reaction time after the event. That is not good planning. So, not that my amendment was the end-all, do-all. I think Neil made that clear. But it did put the people of Montana first. It put these captive customers first. The customers they're talking about can go anywhere for a good deal. And they can sell for almost any price and make a big profit. But the people of Montana, and I think this goes to what Commissioner Pinocchio was talking about, they will be stuck with the CapEx of new construction of new generation, while those who receive these contracts will not. And that is simply not fair. To say that we're not even going to put this in as a discussion point, I think this is about as wrong as it can be. I'm not going to keep fighting uphill on it, but I'm about as no as I can be on this motion, sir.
Further discussion.
I'd like to close on my motion when the time comes.
Seeing no further discussion, go ahead.
Thank you, Mr. President. I think there's some very big misunderstandings here from some of my colleagues about what this motion is and what it does and what it doesn't do. So what this motion does is it approves the operations on an interim basis. It approves how to deal with these designated contracts on an interim basis. It protects customers from having to pay any costs that exceed the O&M costs that exceed those contract costs that are coming in on these shares, the Vista share of Colstrip. As our staff noted in the memo to the commission, and I wish commissioners would really read these things because it sounds like they haven't, some haven't, but the staff noted that the commission may benefit from additional testimony and a hearing on this matter before making its final decision on prudency, and approving the motion on an interim basis would allow deeper development of the evidentiary record. That's a direct quote from the memorandum here for us. So this is what we're doing, at least if we approve the motion. We're going to be able to develop an evidentiary record. We're going to be able to explore all of the deeper issues and ideas on this situation. This motion doesn't preclude us from doing any of that. It opens the door for that while allowing the utility a pathway to recover some of the O&M costs, because these O&M costs are not free, they're huge. And instead of having the customers, the other Montana retail customers to pay for them, they found a way to sell some of that energy to some other companies, energy companies in Montana, so that money can be put into O&M, because the plant, although the purchase price was free, $0, operations and maintenance is in the tens of millions of dollars a year. So this will allow the company to cover some of those O&M costs and protect customers from that, even the company even asking customers to cover those in the future. So I think it's a reasonable and sensible approach from what we can see now and the information that we have on it now. And it allows us to dig deeper on this and come back at any point that we want, because of the way the motion is framed, to adjust it and do something different if we want to do something different. So I guess I'll just close with that, Mr. President, that the motion is to adopt the staff recommendation as it's recorded in the final 2 paragraphs of the staff recommendation. That is the intent of my motion. And I think we've got good analysts that did good work on this, and the utility put together a little bit of an out-of-the-box solution for how to cover those O&M costs and be able to sell some of that excess energy that it has. And I'm happy to say that our regulated utility has excess energy to sell, because when I came onto the commission, they didn't. We were short, and we opened a resource adequacy docket in 2021 because we were very, very concerned that our utilities in Montana did not have enough energy to meet the demands of customers, especially during extreme cold weather events. And now, because of some of these decisions the utility has made, Northwestern has made, they're in a long position where they've got more energy than the retail customers actually need. So they're coming up with some ways to do something with that energy to help offset the costs of operating Colstrip. They've been able to save Colstrip and keep it in Montana, and having reliable energy in Montana is an important thing to do. And I would hate to see any commissioner vote against doing that. So that's why I think that it would be helpful and advisable for commissioners to support the motion. Thank you, Mr. President.
The question, would somebody call for the question?
I call for the question.
The question's been called. The motion before us is to approve staff's recommendation for Northwestern's motion for temporary waiver on tariff provisions on an interim basis until a supplemental order is issued at the completion of the PCAM docket. All in favor, please. All in favor, please signify by saying aye.
Aye.
Aye. Opposed?
Aye.
Aye.
Motion passes 3-2 with Commissioners Molnar and Pinochi dissenting. Thank you. Number 3 on the agenda today is docket number 2025.09.071. Give staff a minute to get set up. What this essentially is regarding Highland Crude, the notice of acceptance of common carrier status, to consider accepting Highland Crude's notice of acceptance and grant it common carrier status. Welcome, Mr. Attorney.
Thank you. Good afternoon, Mr. President and Commissioners. For the record, I'm Joel Turney. I'm a PSC pipeline staff member here. Today, as you mentioned, is the Highland Express pipeline. Staff had written a memo concerning this docket and was routed to the commission last week, but I'll give you kind of a brief synopsis. September 2013, Highland, which is a company owned by Kinder Morgan, filed a notice of acceptance of the provisions of Title 69, Chapter 13, as they built a 12-inch crude oil pipeline from North Dakota to Wyoming, transversing various counties in Montana. And in 2015, that pipeline was put into service as a crude oil pipeline and has been transporting crude since 2015. In September of 2025, Highland notified the commission that it intended to convert this pipeline from crude oil service to natural gas liquid service. And just for information, natural gas liquids would be ethane, propane, butane, pentane, and will continue to accept the provisions of Chapter 13 and remain a common carrier pipeline. Under Chapter 13, a pipeline carrying crude petroleum products or products of crude petroleum may make a filing to accept the provisions of the chapter and become a common carrier pipeline, which gives the pipeline operator the right of an eminent domain. A natural gas liquids pipeline fits under that statute. It's a product of natural gas liquids as a product of the crude petroleum. In the case of Highland, with the conversion from crude to natural gas liquids, now the pipeline has already been installed. The pipeline is not coming out of the ground. The pipeline is there. So they're going to do a conversion of service, which is quite common in a pipeline. And so the existing easements that they had with the landowners, going across the landowners, some of the existing easements allowed them to, the easement specifically said it had to be crude oil. Some of the other easements specifically said it could be crude oil or other hydrocarbon products. So the ones that didn't allow for other hydrocarbon products had to be renegotiated. So that's the process of where the negotiation of easements came in. And as Highland filing a letter here is saying we accept common carrier status, they have the right to condemn that under the eminent domain, which the commission has no say whatsoever in easements, route of the pipeline, commodity of the pipeline. Even in this instance, we would have no safety jurisdiction. It will be PHMSA that will do the safety jurisdiction. It's a liquid pipeline that will fall under the 195 code. The commission did receive various motions and public comments from landowners affected by the pipeline concerned with the Highland pipeline. The legislature granted crude petroleum pipelines the right to eminent domain if they accept the provisions of this chapter and become a common carrier pipeline. Now, if they didn't want to become a common carrier pipeline and they could build the pipeline and get the easements without using condemnation or eminent domain, they would not need to make, they wouldn't be a common carrier pipeline. The trade-off, once they accept the provisions of Chapter 13 and come in and say, we're a common carrier pipeline, they will always be a common carrier pipeline. They could never come back to this commission and say, now we want to reverse course and not be a common carrier pipeline. So once they're a common carrier pipeline, that's noted. So if somebody came along, somebody else wanted to ship natural gas liquids on that pipeline on an intrastate move, meaning 2 points within the state of Montana, the third-party shipper would build an unloading facility, build an offloading facility within the state of Montana. And at that time, then Highland would have to make a filing with this commission so we could establish rates for the movement between point A and point B. But until that happens, we will have nothing to do with it. It'll be in the file that they're a common carrier pipeline. If somebody chooses they want to ship on that pipeline, then they would be allowed to, because Highland is a common carrier pipeline. That's what the legislature granted to them. And as I stated in the memo, in closing, I believe that the only option that the commission has is to accept this filing as their filing saying we accept the provisions of Chapter 13. The commission can accept that. Now, this may be a question for legal, but I'm not even convinced that the commission would have to accept that. They've filed the letter. We docketed it, they filed it and said, we accept the provisions of Chapter 13. That might be all we need to do. The commission may not need to say, okay, we accept your letter of accepting the provisions, but we have done that in the past. And that is the purpose of today, is for the commission say, yes, we accept the provision, we accept your filing of your acceptance of the provisions of the common carrier pipeline, be put in the file. And then if somebody wants to come ship at that time, we would open a docket on it and just establish rates. But until that happens, I don't believe there's anything. The legislature, in my mind, and I've been doing this a long, long time, the intent was very clear that they gave the intent to these crude petroleum pipelines the right of eminent domain. They accept common carrier status and with very little oversight of this commission. So we couldn't stop them from building it. We can't tell them not to go here or not to go there. We can't establish any rate on that pipeline. It's just, it is what it is. And that's basically very limited jurisdiction of what we can do. I would be available for questions if there's questions.
Thank you for your presentation, Mr. Attorney. Are there questions from our commission? Commissioner Pinocci.
Well, I want to thank staff. I think your explanation was correct. And I have been fielding phone calls all weekend long, Friday, I'm sure too. And my job as an elected official is to listen to concerns. And I explained that they should call this office and make a complaint or get some safety concerns clarified. I'm directing phone calls to you, sir. But at the same time, some of the concerns were this: crude going through my backyard is much safer than natural gas. If I hit a crude line with a plow or we have some sort of incident, the risk is much lower with crude than natural gas or propane. Would you agree with that?
Not necessarily. A crude, if you hit a crude line and going through your property, you're going to have a way bigger environmental concern than you're going to have if you hit a propane line or a natural gas line, because it's going to start vaporizing. You're not going to have, I'm not exactly sure what the flash point is on crude oil. I mean, it could still probably ignite and cause an explosion. I've seen that happen. So, I mean, as far as I understand, I mean, I've been doing this for a long time, and you got to realize that pipelines are the safest mode of transportation for energy, no doubt about it. Moving crude oil down a pipeline, moving natural gas down a pipeline is much safer than having crude oil going down rails and rail cars going down the road in a truck, moving down, and they're very safe. And fortunately, that's what we do with the natural gas here. Was we try to get to zero accidents. Is that possible? I don't know. There's a lot of externalities that may prohibit that. But there's not a lot of times that there's a release on a pipeline unless there's something that a third-party intervention, somebody digs into it or something like that. So I mean, me personally, I may rather have a natural gas pipeline next to my house than a crude oil pipeline, only because there'd be less environmental concern cleaning it up.
Follow up. Well, I think the landowners feel that moving from crude to natural gas or propane, they'd like to understand the differences that they originally agreed to crude. And I think it's a fair question. I don't think that the Public Service Commission can handle those issues, but it's certainly my job to listen to their concerns and direct them to this office. And I've had to deal with a good amount of phone calls, and I think it's a fair question. And I, witnessed a large gas pipeline in Sims explode about 40 years ago, and the shock wave was heard, 3 miles away. And I've never heard that with a crude oil line. So I would much rather have crude oil, I think, and 300 yards from my house from natural gas. And I think the lady's concern is warranted. I do. So I'm trying to balance these concerns and voice them that they're saying, look, if we're going to move from crude to natural gas, maybe we should sit down and understand the differences there. So I just wanted to voice my constituents' concerns. Thank you.
And if I can add a little bit to that, I have talked to some of these people, and if they have concerns on the safety end of it, obviously this agency and our group do not do the safety inspections on this. We don't have the pipeline. The US DOT PHMSA office, pipeline safety does, and I have plenty of contacts that we could put them into. And PHMSA has people in the Western region. I'm very good friends with one of them that would be happy to sit down and try to alleviate their concerns about the product in the pipeline.
So, thank you, Mr. President. So I read the public comments, including individual landowners and their hired attorneys. And at the PSC, we deal often with misunderstandings about PSC jurisdiction from people that are seeking help with their very legitimate concerns, like Commissioner Pinocci talked about. So in this Highland crude case, our jurisdiction is very limited, as you discussed. Nevertheless, for the sake of improving public understanding, I have some clarifying questions, primarily for the public. So David Jurica, he was a public commenter this morning, and he asked about the change in commodity from crude oil to natural gas liquids. And on page 2, first paragraph of the Highland Crude's notice, the NGL, it says the NGLs to be transported are produced in conjunction with conventional and unconventional production from crude oil wells in North Dakota. Is this why we do not have to address a change in commodity from crude oil to natural gas? Because it starts in North Dakota in crude oil wells. Is that why we don't have to?
Natural gas liquids are not natural gas per se. The natural gas liquids are what is produced in conjunction with the production of crude oil or natural gas. So as I stated earlier, a natural gas liquid would be an ethane or a pentane or a butane or a propane that come up when they're producing that, and they're a valuable commodity. So they want to move those out and get them to market. So they are, by Chapter 13, considered a product of crude oil. That's why they're allowed the same rights as a crude oil pipeline under Chapter 13, because natural gas liquids are considered product of crude oil or crude oil product.
Okay, perfect. So that's Montana Code Annotated 69, Chapter 13, 101, Paragraph 1 that you've referred to. Okay. Another question. There are some landowners, and this has to do with eminent domain, and I realize that's not in our jurisdiction. Nevertheless, I mean, they're very passionate about that particular issue, and coming from, the Flathead and my liberty-loving constituents, they have concerns. We're on the opposite end of the state as this, but they have concerns about eminent domain. So it's a really big deal. So it's not in our jurisdiction, but I still have some questions So you've been fielding a lot of questions. Have you and other staff in their correspondence with the landowners and their attorneys referred them to agencies that could help them with these eminent domain questions?
Mr. President, Commissioner Bukacek, I have not, I have in various cases, not necessarily not in this case, but in cases where I've discussed with people before, I highly recommend that. And I just had one the other day on a different pipeline, that if you're unsure of what you're doing, that you should hire yourself an attorney, right? Because this easement is a private contract between yourself and the pipeline company. There, as far as the eminent domain and what rights they're granted under them, that would be something, again, that an attorney would have to explain to them as to what their rights were under eminent domain. I mean, my understanding has always been that if they come in and condemn, like a highway department, state highway comes through and they condemn property for the right of the public, they use eminent domain, and then they have to pay you a fair market value, right, for your land. That's generally, I believe, how that works. It's probably the same type of a situation when the pipeline companies coming in and try to negotiate an easement. They probably start, and I've never been in one of these negotiations, but they probably start with a price that they feel they want to pay you, and there's a negotiation that goes back and forth. And I'm assuming those negotiations can break down pretty easily. And then they pull that tool out of their thing that, well, we have the right of eminent domain, so we can come through here anyway, and we'll pay you what fair market value is. I don't know if that's what's happened in these cases, but that could happen.
So some of the landowners have hired attorneys. We had one of them here today making public comment. So they've contacted us, and we're not the proper jurisdiction. So what would be the proper jurisdiction for those attorneys to counsel their clients?
Mr. President, Commissioner Bukacek, I'm going to steer away from legal advice.
Yes.
Here, I don't want to be telling them where they should be bringing their legal concerns. I guess my answer is not here. I completely understand their concerns. Unfortunately, the statutes just don't allow us to address them.
Okay, so I have some more questions that are irrelevant to us, but I think it's important. So, to convert the Double H pipeline from crude oil services to natural gas liquids, can you give me an idea, this would be for Joel, what you estimate would be needed to change the pipelines? What would Highland need from the landowners? How many acres, or do you have any idea?
There should be no change of the pipe itself in the ground. There may be some changes in, a crude oil pipeline has a pump station versus a compressor station. I'm assuming they may have to change out some of that stuff. I don't know if there's any land associated that's going to take up more space than what they existingly have.
But potentially nothing.
It could potentially be nothing. You're correct.
Would you say probably?
Potentially.
Okay. Right. All right. Okay, a couple of more things. If you could please address the concern by Lund Law that the denial of landowners' motion to intervene was illegally made by PSC through, quote, through delegation to staff, end of quote. Could you address that, please?
Mr. President, Commissioner Bukacek, in our internal policy manual, staff has the authority to issue orders that do not require a vote from the commission, but this follows a 2-day review by the commissioners. So staff will send an email to the commissioners giving them 2 days to review any orders that do not require a vote. When that's done, the signature block has to contain that required language of, quote, through delegation of staff. But as I just stated, that language does not indicate that the commissioners haven't reviewed it, just means it wasn't voted on. And
so why does it not require a formal vote or a business meeting? Why, there's reasons why that is not required.
So I'm just trying to think of the right way to walk you through this. We can do that in matters that are uncontested. This docket is considered an uncontested matter because we don't have the authority to do much. You know, we can accept their acceptance, we can accept their notice, and that's pretty much it. So there's nothing really to contest. There's no hearing or evidence to be had. Therefore, this is considered an uncontested matter, and we can issue decisions without a vote. That being said, we're in front of you today because clearly there's concern from the public here, and in the past, we have come before you for a vote. And so we're doing a vote now, but that's why one wasn't done before, was because it's an uncontested matter.
And it's that would be a little bit circular though, in terms of logic, I think, because they weren't allowed to intervene. So it's uncontested because they weren't allowed to intervene. Correct?
Correct. And that, again, that order not allowing them to intervene was given to the commissioners to review, it just not with a vote.
Thank you.
Mhm.
Two more irrelevant ones. One intervener or one constituent pointed out that Highland has not yet filed an application. What is the legal difference between filing an application and filing of acceptance of common carrier status? If you could explain that for the public. You've explained it to me very well.
Mr. President, Commissioner Bukacek, an application is asking the commission to review the filings and review the evidence and make a determination on whether that decision was just and reasonable, or whether that rate is just and reasonable, whether there's sufficient evidence to support it. A notice is just putting the commission on notice that something is happening. It's not asking for approval of a rate or approval of a license. It's just saying, hey, we're doing this. Because of that difference, as Joel indicated, Highland's not asking for permission or approval of anything they're doing. They're just putting us on notice that it's being done, so that in the future, if someone wants to ship on the pipeline, we can issue rates. So I don't know if that answered your question as well as I had before, but the difference is basically that a notice is just putting us on notice that something is happening, as opposed to asking for permission.
Okay. One last one. It's been conveyed to me that objections and requests by the landowners and the attorneys have been ignored. Could you describe for us staff interactions with landowners and their attorneys? I don't mean details, but just attentiveness. If you could describe it in general, attentiveness to the public concerns.
Do you want to take that?
I've talked to them, personally via phone call, on a couple of different cases, a couple of different occasions. Mr. Jurika specifically, I've not spoke with the other ones, and they've, you know, I think just given the context of what this was, that their public comments have been come in, and it's just like any other public comment. When a person makes a public comment here, we don't necessarily respond to it. I mean, Tina's group, I believe, does respond to, but not with any substance. I don't believe that, you know, we've received your public comment, what it may be, but it's just generally the way that legally that we've done things. I mean, it's not that they were ignored by any way, shape, or form. You know, we've read all the public comments. We know what their comments are. It's just that some of the comments that they made were wanting things that we can't do by law. I mean, the statute doesn't allow us to do that. So, I mean, we certainly would do, if there was more that we could do or had to do, we certainly would do it. We're just confined and constricted by what this law allows us to do.
Very good. Thank you. That's all.
Further questions?
I have one.
Commissioner Molnar, and then we'll get to you, Commissioner or Vice President Fielder.
Thank
you. Thank you, Mr. Chairman, for both. Not counting Mrs. Lund's commentary a moment ago. Have you heard anything from Highland about the two court cases she mentioned?
No, I've not.
You?
No.
Follow up very quickly, Mr. Chairman.
Follow up.
Would it be customary for a regulated utility to let us know that the courts have accepted jurisdiction over issues that they currently have before us, and that the courts could easily negate anything we would do.
I would say at this point, Mr. President, Commissioner Molnar, that they're not really a regulated utility, right?
Well, they're here, whatever you want
They
to call
just,
them.
they just made the filing and said that we accept common carrier status. I wouldn't classify them a regulated utility until such a time that somebody decided they wanted to ship on that pipeline, and then we were establishing rates. Then we could consider them a regulated utility, and then we'd be establishing rates, much like on the Yellowstone pipeline or the Front Range pipeline that carries oil. We have rates that are established that this commission sets for that. But until that point, and also since we have no say or no dog in the fight, for lack of a better word, with easements, I mean, it's probably something that it would play out in a court. I wouldn't be something this commission could probably do anything about anyway, or would intervene into.
Well, Mr. Chairman, that may be, let me rephrase. If an entity has an issue before us that we are going to rule on, normally, would it be customary for that entity to notify us that there is a court action?
Mr. President, Commissioner Molnar, I'll start my response by saying what's in the courts is not before you. The easements are in the courts. What we are deciding here today is not about the easements. It's about whether Highland will be required to ship a third-party shipper's natural gas liquids should a third-party shipper choose to do so. However, that being said, if that common carrier status were somehow in the district court, I would assume they would notify us, but that's not the case here.
Thank you. Mr. Chairman, whenever we're done, I'd like to make a motion.
Vice President Fielder.
Thank you, Mr. President. Can you hear me okay?
Yes.
Okay. I too have heard from a number of folks out here. I think there's 3 different families that family members have contacted the commission through public comments. Some have written letters and sent emails and called. I've talked with some of them. I've looked into this. Private property rights are sacred. They're just very high on my priority list in terms of protecting them. And if we had the authority to protect the private property rights that are at issue here, I would be trying to exercise whatever powers I had under the law to do so. But I don't think we have that. It's clear to me that that by accepting the notice, we are simply accepting the notice, and we're not granting permission for the pipeline to change commodities or exercise eminent domain. They, by their nature, have determined themselves to be a common carrier, and under the statute, we don't have room to say otherwise. And if the court rules that we do, then fine, we'll revisit it. If there's a way for us to, help prevent eminent domain from being exercised in a way that is improper or unfair, as some of these folks have indicated, then I'd love to help them, but I just don't see a way here. I think that those responsibilities do fall with other agencies and are not within our jurisdiction. It's kind of unfortunate because I love private property and protecting private property rights, and I wish them well, but I just don't think that that's within our purview as a body, and the legislature set specific statutes that we have to implement because we're part of the executive branch to execute the laws, not make them. So I was going to ask staff a question. I'm sorry to elaborate before I ask the question, but the question for staff is, were they even required to give us this notice that they filed in September?
President Wellborn, Vice President Fielder, I'm not really sure. I mean, they did when they constructed the pipeline 10 years ago that they were a common carrier with conversion to service. I don't know if they necessarily needed to notify us that they were a common carrier. I guess that's a better question for Teresa.
Mr. President, Vice President Fielder, I will note that in Highland's notice, they did say, I believe it's a quote, in an abundance of caution, they were notifying us. Because frankly, I don't know that anybody's sure they had to notify us again. My legal interpretation doesn't really matter at this point because they did notify us. And so we're just stuck accepting it because they filed it. Whether or not they had to is up for debate, I guess.
Mm-hmm. Well, I appreciate the fact that they did, because there are a number of companies out there that don't notify us when they should. And so out of an abundance of caution, appears to me to be responsible action on their part to notify us, not knowing that they had to or not had to. But yeah, I don't see we have an option other than to accept their filing. We don't have a basis to reject it. I mean, I don't see a basis to reject it. Is there any basis to reject it that staff has identified?
Mr. President, Vice President Fielder, the statute only requires that they state in their notice that they are willing to accept the responsibilities that come with common carriers. And in their notice, they do state that. And so that is why staff is recommending that we accept the notice.
Okay, thank you.
Commissioner Molnar.
If there's no further questions from commissioners to staff, I'd like to make a motion.
Go ahead.
Okay, my motion, Mr. Chairman, is to suspend for the time being any action on this. And once the court actions are done, we can take a look at what, if anything, still needs to be done.
Second.
I'll second.
It's been moved and seconded. Discussion on Commissioner Molnar's motion. Commissioner Pinochi.
I do see a possible issue where if this is in court, perhaps if we're going to respect property rights, we should wait and see what the court's decision is. And I think that shows that we're listening and we are concerned about property rights. I also think that the legislation, when they tell the commission what to do, they're really doing the best they can with the information they have. And I think if the legislation could take a look at this situation, they may clean things up a bit and give us a little bit more say. Some good questions that have come up is, look, if this is going to be natural gas, should there be a little sign that says, warning, natural gas pipeline? Landowners are telling me they're not sure where the pipeline is. And I think that is concerning. I drag a plow over a gas pipeline, and every time I do, I hold my breath. And when I run a ditcher, which is deeper, it's a little frightening, even though I know where that line is. For people that don't know exactly where that line is and they're trying to farm, I think that it should be clearly marked. And if they're going to court, we should wait. And also, I plan on talking to the legislation about maybe making this a little bit more clear in the future, so that we have a little bit more direction. The way things are, I do think we should answer questions and comment. I know we don't. I don't agree with that. The reason I don't agree with that is because my constituents don't like it. Anyway, that's what I have. Thank you, Mr. President.
Further discussion on the motion?
Mr. President?
Commissioner Bukashek.
Sir. So since it's a different motion, may I ask staff question?
Yeah, I'll allow that.
Okay, thank you. And I understand public commenters have asked us to suspend the action, so I've gotten the same requests, and I understand the emotional appeal of that. So the question I'm asking staff is, I mean, whatever the court decides, it will still be outside our jurisdiction, correct? So, is that correct?
President Wellborn, Commissioner Bukacek, my hesitancy in answering that question is I really hate to guess what a court's going to decide. Um, but my understanding is that what's in front of the courts is regarding the easements, which does not have any bearing on what we're deciding today. So my tentative answer is yes. We would be outside of that jurisdiction.
Whatever the court decides, no matter how they decide, chances are it would be still be outside our jurisdiction.
Chances are, yes.
Okay, and only the legislators can put it back in our jurisdiction, correct? Not the courts.
President Wellborn, Commissioner Bukacek, correct. That's correct.
Okay. On that basis, I'll be a no vote. And I understand the emotional appeal of this, but I will be a no vote. It's just not rational.
Further discussion?
Mr. President,
Vice President Fielder.
thank you. Commissioner Molnar, I'd like to ask you about your motion. So your motion was to suspend any commission action on this matter until after the courts render a decision. Is that right?
Correct.
Okay, so based on my understanding, the Highland didn't even need to put in further notice with us. They did it, we have it, it's on file. Commission action, I don't think is even necessary. So I can support the motion because I don't think commission action is necessary anyway. So that's fine with me, if we don't act on this today or at any time and unless and until we actually need to. And I don't, from what I understand, we don't actually need to act on this.
Thank you.
Point well taken, Vice President Fielder.
Mr. Chairman, can I defend, or did you have a question? I'll defend my motion.
Yep.
I don't think it's that complex. Fellow commissioners, you have a yellow highlighted document that I cranked out, and that's part of the reason I was late. On the first page, second paragraph, in Powder River, the court has taken control. No matter what we think, what is filed, what may be filed, the court is going to rule. I don't want to have our legal team going to one of two courts, debating our authority on something that we're not even sure that we need to do. Second sentence, same paragraph. The minute order December 30th, so this is last year, but just barely. The motion for summary judgment directs the case to proceed to court. The next one, third one down, the filing for summary judgment was denied. The judgment for denial of claim was denied. Regardless of what we think, our staff thinks, and I got to tell you, anything to do with pipelines, I go to you. You know far more about it than anybody I know. And however, the courts don't seem to think that this is a case without controversy. It's a case in controversy. You flip the page, Highland Crude LLC does continue with the request for a hearing on the motion for summary judgment. They didn't get it. Motion for summary judgment is denied. Next paragraph. It's a case in controversy. Next one, expert disclosure is required by January 15th. That's in 2 days. Talk about a rush to judgment on our part. In 48 hours, we'll see what their experts have to say. The next page, 2/3 of the way down, these are condemnation proceedings. And that's why they receive expedition and priority considerations. Everybody recognizes the high level of importance to somebody else telling you how they're going to use your land and cutting you a check based on what their real estate experts say it's worth. And then you go into court to fight over the difference and trying to wonder if it's worth the legal cost. This is a condemnation proceeding. And correct me if I'm wrong, maybe things changed, but, Joel, back in the day, I made the motion for common carrier status to the XL pipeline, which gave them condemnation. Has that been changed? Was this somehow different from that?
Mr. President, Commissioner Molnar, I can't recall that, but I would suspect that was just the same thing that we're trying to do today. Basically, they filed a letter of acceptance of common carrier status, and the commission acted on it just to accept that letter of acceptance, and that's most likely what you voted on.
Okay. Mr. Chairman, thank you for letting me go back into staff there for a minute, but that popped into my head and I thought it was important for a final decision on this. Page 4, top line, a bench trial is docketed for March 10th. In 2 months, almost to the day, the trial begins. I do not want to become a party to something I'm not a party of right now. Let the court handle it. Ms. Lund will bring forward her arguments. Highland will bring forward theirs. If it crosses into what we're talking about today, I don't want to be there. I'll let the judge decide. And the last page, and this is the other case, and this is just the title page, I guess is what I'd call it. If you look at who all is the plaintiffs in this, Burlington Resources Oil and Gas, they're huge. McKinsey Electric Co-op, Reservation Telephone Co-op, American Bank Center, Quest Corporation, Stockman Bank of Montana. These are some heavy hitters that think this is a case in controversy. If this doesn't go to the Supreme Court, I'll eat my hat, and that could be both courts if their findings are somewhat dissimilar. I say we stay out of it. We let the courts decide what they're going to decide, and if there's something left for us to do, and if Highland still wants us to do it, we take it up at that time, Mr. Chairman.
Thank you. Yeah. Commissioner Bukashek.
So I totally understand the emotional appeal, especially since we're elected officials. I get that. Is there any downside to suspending this action?
Mr. President, Commissioner Bukacek, the potential downside to not issuing a decision would be Highland bringing us to court for not making a decision quick enough. We have no statutory deadline for making a decision, so I don't see that as a big possibility, but that would, I mean, Highland's the only interested party in us making a decision at this point, so them bringing us to court over something would be the downside that I could see.
Okay. They weren't even sure they need to let us know, so
Mhm.
so it's not very likely. Thank you.
Commissioner Pinocci.
Does staff feel you should have been notified that this case was in court before we were notified to vote on this?
Mr. President, Commissioner Pinocci, no. I don't feel it's relevant to what's happening here, so notification would not have benefited us in any way.
The courts and the judges in Montana is like the Wild West. They do not follow law. They make rulings from the bench that don't follow Montana law. Because of that, I think it's good caution for us to wait, especially when I look at property rights. I will promise to work with the legislation to try to get this cleared up to where any entity is required to let us know they're in court if anything's at the Public Service Commission. And I'm going to encourage the legislation to straighten that out. Thank you.
All right, there's a motion before us.
Mr. President,
Yes.
before we go, I'd just like to note for the record that support of the motion is not rejecting Highland's filing, it's suspending action on it at this point. And I think that's an important distinction.
Thanks. Thanks for that clarification. And before the question is called, would you read your motion verbatim into the record another time, Commissioner Molnar, and then I will.
Does the secretary have, so I don't put a word in or leave a word out? Barbara, did you write down my motion? Okay, Mr. Chairman, then my motion would be to suspend action on docket 2025.09.071 until after the courts have ruled. And then if there's something that we need to rule on, we take it up at that time.
Question. All in favor of Commissioner Molnar's motion, please signify by saying aye.
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 Opposed? Vice President Fielder, we didn't hear your vote.
I voted in favor of the motion.
Okay, I didn't make that, so the motion passes unanimously. All right, thank you. Thanks, Joel. Thanks, Teresa, appreciate it. Moving to number 5.
Mr. Chairman, can we take a quick 5-minute break by any chance?
Yeah, we can do that.
Thank
We'll reconvene at 3:45. We're in recess.
Call you back. You're not gonna call back.
If you'll go to tab number 5, agenda item number 5 is the commission initiated PDF remediation software purchase.
Mr. President, I apologize for interruption. I believe we're on number 4.
I'm going to get a speeding ticket. And I'm not sure if this is the proper jurisdiction to pay that or not, but I've got my checkbook out. Okay, let's go back. Let's back up to item number 4, the annual pipeline safety rule update.
Good afternoon, commissioners. You're stuck with Joel and I again. Before you is a draft notice of adoption to finalize the annual pipeline safety rulemaking. This will update the incorporation date of the federal pipeline safety standards from 2024 to 2025. This change is necessary to allow the commission to use the most recent federal rules and remain in compliance with federal funding requirements. The commission previously voted to propose this rulemaking on November 25th and published a proposal notice on December 5th. The public comment deadline on this matter was January 2nd, and we received no public comments. The final step is for the commission to adopt the final rule. Accordingly, staff recommends approving the draft notice of adoption and authorizing staff to make any non-substantive edits as necessary for publication. And we're happy to answer any questions.
Thank you, Teresa. Are there any questions from the commission? Seeing none. Would somebody like to make a motion? Commissioner Berkesek.
I move to approve the draft notice of adoption and authorize staff to make non-substantive edits as needed for publication.
Thank you. Is there a second?
I'll second.
It's been moved and seconded. Discussion on the motion. Seeing none, all in favor, please signify by saying aye.
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 Motion passes 5-0. Right. And I believe number 5 is what we deferred till a future work session. Okay. We are on agenda item number 6. Our travel reports. And if you'll turn to tab number 6, in no particular order, we can go through them however commissioners would like. Commissioner Pinocci.
Thank you, Mr. President.
Excuse me, Mr. President,
Yeah,
before
go
we get
ahead.
started. I reviewed the travel reports. I do not have a travel report because I haven't had official travel this quarter, and I'd like permission to be excused if I may.
Permission granted. Thank you, Vice President.
Thank you.
All right. Well, we can, Commissioner Pinocci, as long as we started down that road, let's
Thank you, Mr.
go
President.
with you.
Yeah, we'll talk about the Seattle, Washington NARUC event, which started on 11/9/2025. The total cost was $2,595.60. Taking part in trying to reduce fire risk, and they're looking at some goals that each state can reach, which I think would be interesting to compare Northwest Energy's fire risk to what NARUC is saying. Hey, this is some things that need to be looked at to reduce fire risk. So there was a lot of education on advanced vegetation management, which I don't think was answered very well a few days ago in this very room. And we talked a little bit about high performance conductors, which haven't started a fire anywhere in the country or in the world. And the ability to monitor the line to where a bird is building a nest or a tree branch is touching, this technology is now available. And I think we should use that in every high-risk fire area. Several companies offer this technology, and I was in touch with a conductor manufacturer, Epsilon, and they are claiming that they can manufacture a carbon fiber conductor for the same price of a steel core conductor, and that is just incredible news. So I think that was a great event to go to, and we're going to take some of what we learned and try to apply it here. Then we took part in travel to Little Rock, Arkansas, and it looks like that event lasted a few days, and we're going to take part in the Southwest Power Pool, and hopefully, working with Will, we're going to come up with a staff member who might be able to work on that with us. So I'm anxious to work with that. Looks like that took place November 1st, so right before I had to leave for Seattle. Total cost was $1,209.55. And Southwest Power Pool did not bring up fire concerns and liability, which I thought was important to talk about because the whole country is really paying for the billions of dollars of damage that just happened in California. And insurance companies are now looking at tremendously raising the rates to utilities or not insuring the utility at all, where the utility may have to be self-insured. And what could we do to try to get a insurance break, kind of like you have a car with anti-lock brakes or safety features, you may pay less. The question is if the utilities step up preventing fires by installing equipment like high-performance conductors or running drones up and down the line to see if trees and vegetation are getting close, could they get a lowered rate? And this is something that I think we need to work on because it protects the ratepayer. It also encourages the utilities to really step up and prevent fires. So that became a greater topic, probably because I was there, than it was if I was not there. And I think there was a lot of appreciation towards that. So that is my travel report. Thank you, Mr. President.
Thank you, Commissioner Panocci. Commissioner Molnar, would you like to go next? And then we'll just follow along in order.
Okay.
Thank you.
Alphabetical order or birth date, or what are you thinking? Whatever.
We'll think on the fly, yeah.
Okay, thank you, Mr. Chairman. Cost of my travel also was to NARUC, $2,052.76. The two things that I went on were actually data centers. They were going to have a couple breakouts on that, and what other states are doing on fire remediation plans, et cetera, what to do about insurance, as Commissioner Panocci said. The one big one I went to on that was actually a very large room with a lot of people up there talking about it. And, I got to say, it was basically cliches. There's nothing I heard there that I haven't heard here. On the data centers, the entire focus throughout the convention was on water. If they don't use much water, don't worry about it. Well, there's a lot of issues besides that. I went to one lunch, and I've never seen this before, Mr. Chairman. Every other seat was empty when I got there because people representing data centers had sat down with the open seat for whoever went in there. Whatever your question, whatever your comment, you had two data center people right there to help you along. They were leaving nothing to chance, is what somebody might say. And kind of as an aside, several times I'm walking along doing my thing, and people would come up and say, well, Commissioner Molnar. They were all with Black Hills Energy. And they all wanted to talk to me. And of course, I couldn't talk to them very much. But the lobbyist presence for Black Hills Energy towards myself and data centers towards anybody was probably as strong as I've ever seen the effort at a NARUC meeting. So with that in mind, I really don't know what that means. I do know that I was surprised. And I think that we have to be as on guard with what we say when we're at meetings like that, questions we might ask. We don't want to get crossways to where we can't vote on something. But it was more like being a congressman. Lobbyist wanted my time, my ear, my support, my everything. More so than I've ever seen before. And with that, Mr. Chairman, the next person, whether it's based on age, beauty, alphabetical order, it's your choice.
Thank you. Like Commissioner Fielder, my travel in this last time frame did not meet the threshold. My only official travel was to a Class D hearing in Three Forks. So, and I was able to do it in conjunction with traveling here for our Tuesday business meeting. So I had zero travel expenses other than my hotel, which were turned in and below the $500 threshold. So Commissioner Bukasek.
For the same meeting, I was under the $500 threshold as well. Thank you, sir.
And I believe that concludes everybody's. Is there any?
Staff.
Yeah, we do have staff. Okay. So Mike, do you want to go, Mike? Welcome, sir.
There we go. Good afternoon. I'm Mike Sheard. I'm a member of the Commission's Regulatory Compliance Team, and I also attended to the NARUC Annual Meeting Education Conference in Seattle. The meeting ran from November 9th through which is a Sunday through Wednesday at noon on November 12th. The travel dates were November 8th through the 13th. My travel costs were $2,596, which was $55 more than cost estimate. The downtown Seattle lodging was a little higher than anticipated. Conference, like you've already heard, included numerous sessions and panels directly related to ongoing matters before this commission. Major topics, in addition to what you've already heard, included bolstering energy security through resource adequacy, balancing energy affordability, reliability, and environmental goals, data centers, and all kinds of things about data centers, water use, and so forth, wildlife resilience and response mitigation and detection, including a presentation from Senator Sheehy on some pretty interesting ways to detect wildfires, including military-grade detection techniques, telephone number conservation, which I was very interested in hearing about, and some natural gas industry-related matters. I attended 12 different sessions over the 3.5-day conference and learned about a lot of new developments in many of the industries with which we interact and oversee. I learned how other states are addressing and responding to the never-ending and never-changing regulatory challenges. A lot of the states are dealing with the same things that you all are dealing with here. And then it was really nice to meet and visit with peers from around the country, subject matter experts and so forth. So I felt like I was able to gather information that may exist our team and others here at the commission with ongoing projects and workloads. I took lots of notes and picked up a lot of materials from sessions and out in some of the vendor booths. If anybody's interested in my notes or any of the materials, please let me know.
Thank you, Mike, and thanks for taking the time to do that and for sharing what you learned with your colleagues once you're back. Thank you. Appreciate you. Yes, ma'am. Welcome back.
Thank you, President Wellborn. Good afternoon, Commissioners. My name is Brooke Umstead, and I'm a rate analyst in the Regulatory Division. My colleague Disha is also a rate analyst in the Regulatory Division and should be attending online. Okay, perfect. On November 3rd, 2025, Disha and I traveled to Oakland, California for the Western States Wildfire Safety Staff Workshop. This was a conference and roundtable held by the Western Conference of Public Service Commissioners, November 3rd through the 5th, with staff, analysts, and commissioners present from most Western states. This conference was timely given the passage of House Bill 490 in 2025. House Bill 490 required electricity providers to prepare a wildfire mitigation plan in accordance with the bill and submit the plan to its approval authority and commence implementation of the plan no later than December 31st, 2025. Electricity providers will then resubmit an updated or subsequent wildfire mitigation plan to its approval authority every 3 years. The conference presentations provided insights on auditing utility performance to verify compliance with wildfire plans, data challenges in both reviewing and auditing wildfire plans, reliability impacts of wildfire efforts, and wildfire risk mitigation cost effectiveness and customer affordability. These insights allow better reviews of plans and provide ideas for how the Montana Commission could improve its oversight of wildfire activities moving forward. My post-travel accountability form is included in your work session materials. It details the cost of my trip to be $836.06, which is $41.94 less than the pre-authorization amount. This difference is due to inaccurate estimates for airfare, transportation to and from the airport, meals, and lodging. Details on all of these figures are included in the post-travel accountability form. I attest that the travel was in full compliance with the Commission travel policy in the internal policy manual, and I will now hand it over to my colleague Disha to finish up.
Thanks, Brooke. Ms. Disha, are you online?
Yes, I am. Yes, I am. Can you hear
Welcome.
me? Okay. Good afternoon, Commissioners, and I appreciate the flexibility to present virtually. My name is Disha Pansuria, and I am the rate analyst with the Commission. Brooke covered the details of the conference concisely. I just wanted to add that the staff from all the attending Northwestern states, especially California and Oregon, showed strong interest in supporting this journey with wildfire plans, and their involvement could help us reduce time and cost while benefiting from their learnings, which is a positive that the Commission can certainly leverage. My post-travel accountability form is included in your work session materials. It details the total cost of my trip to be $932.68, which is $138.56 more than the pre-authorization amount. This difference is due to inaccurate estimates for airfare, transportation to and from the airport, meals, and lodging. Details on all these figures are included in the post-travel accountability form. I attest that the travel was in full compliance with the Commission travel policy in the internal policy manual. Brooke and I are available for any questions you may have. Thank you.
Thank you. Commissioner Pinocci has a question.
Well, I really appreciate you guys attending this. Thank you. My question is, when I'm studying wildfire risk in California and Oregon and Washington, they have these high fire risk maps showing the areas that are susceptible and are in danger of fire risk. I actually was given a look at a Montana map in California, but what I've been asking is there a Montana map that Northwest Energy is working with to show a high fire risk area? Have you seen one? Yes or no?
I have not seen one, Commissioner Pinocci.
Is there some discussion that maybe they could work on one or we should have one? What are your thoughts?
President Wellborn, Commissioner Pinocci, I think one of the lessons we got from attending this conference is that we just started this process here in Montana with House Bill 490, and it's an ongoing process. And as you can see in the notice of commission action in Northwestern's wildfire plan, docket 2025-08059, that we're working towards developments, which we expect to see in the next wildfire plan. Hopefully that answers your question.
Well, it's a curiosity question because this map is key in these meetings, but it seems to be missing in Montana. Also, the map I looked at was explained to me that we may have more high fire risk area than any other state in the United States, except for maybe California. And there was actually a discussion about California and Montana, which one really had the higher fire risk area. So it's so interesting that we could be number one in the United States, but the only person that seemed to have seen this map is me in California. So the next question is, what do we do differently in those high fire risk areas? And then how do we show the people of Montana that we understand where the high fire risk area is? Here's what we're doing differently. I just thought that'd be interesting, but I really appreciate you guys attending, and I wish I was there.
Thank you. Any other commissioner questions? Thank you both for your reports today and for taking the time to go do that. All right. Ms. Homans, welcome back.
Back again.
It's like Groundhog Day.
Good afternoon, commissioners. For the record, my name is Teresa Omens. I'm a staff attorney here at the department. I'm here to report on travel I took October 5th through the 10th to Madison, Wisconsin for an energy utility basics training. The total cost of the training was $2,871.89. At the training, I received 5 days of extensive foundational knowledge on energy creation, transmission, and regulation. The training contributes to the department's goals to increase staffing proficiencies and defend sound commission orders. I found this training particularly valuable for the jumpstart it gave me in understanding basic concepts, particularly acronyms, that I could build on throughout my time here at the department. I learned a lot, and I appreciate the opportunity to attend such a well-rounded training.
Thanks, Teresa. Is there any questions for Ms. Homans?
No question. May I make a comment?
Certainly.
And her name is pronounced Omens. And the way that I remember it, she's a good omen. So her name is often mispronounced by commissioners. I just would really appreciate it if we could pronounce her name properly. She's a gem.
And I would agree, she's a very good omen.
Yes, she is.
Thanks, Teresa. All right, I think we are to the end of our travel reports and our agenda as well. So the time is 4:08 p.m. And I thank everybody for your time and attention this afternoon. Meeting adjourned.